Hello everybody and welcome back to our studies in land law. In this lesson we're moving on to topic number 7. This topic concerns itself with licenses and the question of proprietary estoppel. This video will talk about licenses. We'll take an introduction to the idea of licenses before talking about the different kinds of licenses and the different ways licenses work in future lessons. And then we will spend a couple of lessons talking about the issue of proprietary estoppel. So in this new topic, we're going to discuss the issue of licenses and proprietary estoppel, as I've mentioned. This lesson specifically will take an introduction to the subject of licenses before we unpack in some detail what licenses are and how they work in future lessons' time. So, the first question that I have to ask is, what is a license? A license is simply a permission for an individual to enter the owner's land without it amounting to a trespass. Simple as that. And obviously from that potentially broad and enlightening definition, we can think about all kinds of licenses for all different kinds of things. The thing that is important about a license and what distinguishes a license from any of the other things we've been discussing, like leasehold estates, for example, or the freehold, of course, is that a license doesn't convey any kind of proprietary right over the property for the licensee. If you have a license to enter a property, you only have personal rights. You only have rights in personam. You don't have any rights in rem over that property. You don't have any proprietary rights over that property. Now, this can extend to occupational rights, but it will not extend to rights that are granted under a lease. So, i.e., rights to exclusive possession of a property or to proprietary interests in that property, all of which can be seen to be occupational rights. Not occupational rights, but are rights that are granted to a lease, but are not necessarily granted to a license. So let's think about this. A license is a personal right, is a right in personam. Since it will not convey any proprietary rights over the property, it only conveys personal rights, it means that there are a number of things that a license cannot do, and it is very limited the kinds of rights, or at least the kind of power you may have over a property in relation to the issuance of a license. You can't transfer, for example, a license to a third party in the same way that you could transfer a proprietary right to a third party, such as an easement or a lease. It cannot be binding onto a third party either. Similar to the idea of like I said, an easement or maybe even a restrictive covenant. These represent rights that are proprietary that can be binding onto a third party. They're not binding onto a license is not binding onto a third party in that regard. Now, one of the earliest, potentially the earliest authority on the issue of licenses comes from the case in 1673. Now, I think I want to do a competition, really, to think about which is the earliest case that I have actually discussed in this series of lessons, or maybe on any of the lessons on the Law Academy. I know for one that there is a case that we discussed not long ago on a different subject that came in 1601. So potentially maybe find that, but I wonder if there is a prize for anybody who can name in the comments the case that has been discussed on the Law Academy that is earlier than 1601. I don't think there is any, in fact, so maybe identify that case, but this is definitely up there in terms of some of the oldest cases that we've discussed. The case here is the case, of course, of Thomas and Sorrel. And what this case illustrates is the fact that a license is not a property right. It is a right that is personal and is issued for the use of land for a specific purpose. This was a case where the defendant had been selling wine without a license, which was in violation of the 1660 Taxation Act, very old piece of legislation. The Crown essentially issued a substantial tax onto the defendant, where the defendant argued that there was an exception in the legislation, where he had the capacity as a member of the Ministry of Vineyards of the City of London. He argued that a royal patent that had been issued by King James I. King James I being the King of England and Scotland from the years 1603 to 1625, said that it could essentially modify the taxation provisions. Now, for those of you who don't really understand or haven't studied any of the history, the 1600s is quite a tumultuous period for Great Britain. We get King James, and then you have King Charles, which then leads to a revolution and regicide, and then we get Cromwell and the as Lord Protectorate. We get the Restoration, and then we get a new monarch in the Glorious Revolution. So it's quite an interesting time period, but that's just a little side point that can be referenced. Go and read that in your own time if you wish to. Essentially, though, he argued that a royal patent that had been issued by King James I could modify the taxation provisions. The court, however, held in favour of the Crown. They noted in one of the reasons as to why they held in favour of the Crown that a licence is merely a personal right, and it is not, in fact, a property right. This was also a case that examined the different kinds of licenses that exist, and this is something that we're going to get into in future lessons' time, so stay tuned for those lessons, like I said, in the future. In the previous lesson, what we did was introduce the subject of licenses in topic 7 of our land law studies. Of course, topic 7 concerns itself with the idea of licenses and proprietary estoppel. We'll get to proprietary estoppel in a few lessons' time, but for now, let's just focus on the concept of licenses. And I'm going to begin in this lesson by talking about the concept of the bare license. This is going to represent the first of a few lessons in which we're going to spend some time looking at the various different types of licenses which may exist. The first, of course, in this lesson being the idea of the bare license. Now, bare licenses are the most basic form of license granted, hence why we are beginning with this particular type of license. Fundamentally, a bare license is simply the permission that is granted on the part of a licensor for a licensee to be given access to the property. So remember, a license is simply a right to be on somebody's property or to be on the property in question. It isn't a proprietary right, it isn't a right in rem, it is a right in personam. It is just a personal right. And a bare license is one such example of this kind of permission which is just granted on the part of the person who is granting the license, the licensor, for the licensee. If you grant a bare license for an individual, you are granting it for the individual to enter your property, then for as long as they are on your property under this license, and so long as they do not go beyond the scope of the license, they cannot be considered a trespasser on your property. That's what distinguishes fundamentally somebody who has been invited, an invitee, or somebody who has permission to enter the property with that of a trespasser. This is this idea of not having license to be on the property. And like it says here, so long as they are acting in conjunction with and in accordance with the potential of the license, the bare license itself, so they're not going beyond what the license allows them to do. So, for example, if I grant permission for my friends to come over and have a cup of tea, and then they start trying to re-wallpaper the kitchen or something, or start painting, or start taking and doing some painting and decorating, then this would probably go beyond what I would consider the scope of that license. They didn't have a license to do that, and so they don't have permission to do that, and they could be considered a trespasser for failing to act within the confines of that license. Now, fundamentally, when it comes to wanting to create a bare license can be made either expressly, or you can imply a license through conduct or words or actions. If they are expressly granted, this will mean that you have clearly given an indication that the licensee has permission to enter onto your property. So, for example, if someone knocks on the door and you respond with, "Come in, come and make yourself welcome," this is an expressed indication that you have given them license, you have given them permission to enter onto your property. Where a license is implied, this is where there isn't this necessary express granting of permission. Rather, and instead of that, there is this general acceptance that they have some license to go onto your property. Generally speaking, an example of this would be a postman or postwoman. They will generally have an implied license to walk through your front garden to get to your front door. And this is not express. You don't give a postman or a postwoman express permission to enter your property every single time they wish to deliver a letter to you. But if you have a front garden, they will have an implied license to enter onto the property in order to give you the mail, the post that is delivered to you. So that's what a creation of a bear license requires. What about the termination of such a license? Well, in these circumstances, a bear license can be terminated at the point at which you want the person in question to leave the property. So at the point at which that person should and it is desirable for them to leave said property, that is the point at which we see the termination of a bear license. The right to invoke a bear license and to terminate the permission of somebody being on the property is illustrated in the following case. This is the case of the Greater London Council versus Jenkins. Now, this is a case from 1975, and it essentially illustrates the ability for the bear license to be created on the one hand, but then also terminated on the other. The landowner in this question has the ability to create a bear license, which then gives and grants permission to the licensee to enter onto that property. They can then revoke said license whenever they so choose, but in order to do so, they must give reasonable time for this ex-licensee to leave the property. Now, what is determined to be, quote, reasonable time is something that will depend on the facts of the particular case in question. And a really good example of this is, for example, if you have a small council flat, then this will probably require less reasonable time for a person to leave than if you have a huge country mansion. If you gave them the same amount of time that you would give somebody a council who lived in a council flat to leave the property, then they might not get out of the property in time because they've got to go down the stairs maybe, they've got to then go out the front door, they've got to get in their car, they've got to then drive all the way through the drive and outside the front gates. That's very different to somebody who owns a small council flat, for example, or just a small flat in general. In order to leave my flat, for example, you would have to go out the front door and outside the front garden. That's a relatively short journey, but it's a much longer journey than somebody just leaving the front door if they were in, let's say, a tower block of flats. So that's just an indication there of how we terminate and what reasonable requirements and expectations are to be given in the termination of a bear license. In this lesson, what I want to do is spend some time talking about a different type of license which may exist in various different forms within land law. This is the idea of a license which may be coupled with an interest. We'll explore what this means in this lesson and then the various contexts in which we can actually establish this principle. Now, as a basic introduction, the previous lesson looked at the concept of a bear license. If you haven't seen that lesson, go back and watch it first. This gives us the most basic form of license that is able to be granted over a property, and it includes what could be expressly stated, so the expressed permission for an individual to enter onto your property, or it could be impliedly permitted, i.e. the implication of the nature of the job, or maybe the nature of the relationship between you and the licensee and the licensor, that could therefore imply the existence of a bear license. I use the example of a postman or postwoman who goes through and has license impliedly to enter onto your front garden in order to deliver the mail. Obviously, you don't give expressed permission at every single time a postman or a postwoman comes onto your property. Sometimes you don't even know they're there. It is only until the dog starts barking that you know that they're there. So that's what the previous lesson examined. This lesson is going to examine the existence of licenses which may arise out of the existence of an interest, and these are known as licenses coupled with an interest. So what what do we mean, and what is the basic fundamental rationale between the idea of, behind the idea of a license coupled with an interest? Well, these kinds of licenses will arise where there is some proprietary interest. Remember, licenses are not proprietary rights. They are only personal rights. They are not rights in rem, only rights in personam. So a license coupled with an interest, however, will arise where there is some proprietary right, some right in rem, that is granted to an individual. And in order for them to be able to use and or enjoy that proprietary interest, they must also have granted to them some kind of license. So the point here is that the license arises out of some other interest which is likely to be proprietary in nature. In these circumstances, therefore, what will happen is that the license will represent a subsidiary interest to the proprietary right. However, so long as that proprietary right exists, the license that is necessary to enjoy that right is irrevocable, because in essentially in revoking a license which is coupled with an interest, you are infringing on the use and enjoyment of a proprietary right, which is of course something that you cannot do as as somebody who is granting a license. Now, there are two cases that I would like to illustrate this point in this lesson after this particular slide. And what really should be noted is that there has been something of a development in the law in this area, because in the traditional context, in the traditional way in which this was viewed, the interest which gives rise to the requirement of a license needn't necessarily be proprietary. However, we see something of a development in this area of the law, and we will get to that in a second. So fundamentally, therefore, just as a basic recap before we talk about the development of this area, a license may exist as being a necessary requirement for the fulfillment of the use and enjoyment of a proprietary interest. That is what we are discussing here. And I will point you to the first case from 1915. This is the case of Hurt and Picture Theatres Limited. This was a case in which the claimant had gone to a theatre, but they were removed from the theatre on the mistaken belief that they had not, in fact, brought a ticket. A ticket sounds quite old-fashioned in terms of the language these days, but this is essentially how theatres used to work. I guess you could say that you have theatre tickets today, but it feels rare to me that people refer to this as a cinema ticket. I don't know why. Maybe because it's all digital these days. It's all done on your phone. Anyway, the claimant argued that, one, they were entitled to be there since they had in fact brought a ticket, and this was actually a mistaken belief that they hadn't brought a ticket. And two, the removal of that individual, which was indeed forcible. It was a forcible removal because he protested the fact that he had in fact brought a ticket. The fact that the removal, which was forcible, happened amounted to a trespass to the person. Now, the theatre, in response, argued that while they may have been in breach of their contract by removing him, because in reality he did in fact have a ticket, and so they were breaching their contractual side of the bargain in the purchase of the ticket by not providing the service of a theatre and a theatre experience in a movie. They argued that, yes, they may have breached their contract by removing him, but once this contract had been in breach, the license to be on the property had been terminated, and they were in their rights to do whatever they so chose and so wanted to do in relation to that individual. They no longer had a license to be on that property as a result of the fact that they themselves had breached their contract by removing him. Now, the courts decided that where there is an interest which is coupled with a license, in this case we have the existence of a contractual interest. The purchase of a ticket at a theatre is contractual, and it is coupled with a license. You have license to be on the property, and you have license to sit in the cinema and watch the movie, so long as you have a ticket, which is of course the contractual interest, which is then coupled with the license. So where there is a license coupled with an interest, that license is irrevocable so long as the interest is still valid. And so the debate here was whether or not the interest was still valid. But the point for us is that the courts held that so long as you still have a valid interest, then you will still have a valid license. And so one cannot revoke the license so long as that valid interest still exists. Couple this then with the 1971 case of Hounslow LBC versus Twickenham Garden Development Limited. This was a case which involved the claimants, who were Hounslow LBC, and they were seeking to evict their building contractors. They applied to the courts for an injunction to be granted against the defendant, Twickenham Garden Development Limited. These were the building contractors. To which the defendant argued in response that since the license to reside on the property was coupled with this idea of a contractual obligation, it therefore could not be revoked. The High Court, however, came to the conclusion that the injunction could not be granted, since there had not been proper notice on the part of the claimants that the contract had been terminated. As such, as a result of this, the injunction could not be granted since there was an implied obligation that the license will not be revoked. It will be irrevocable so long as the contractual obligations remained in place. So in the previous lesson, we spent a little bit of time talking about the nature of a basic license, or a bare license as sometimes described. This lesson is just going to carry on talking about the various different types of licenses that can exist within the broader context of land law, focusing on the idea of the contractual license and contractual licenses. We're continuing to look at the various different types of licenses which may exist. So far, we've spent some time looking at the idea of a bare license on the one hand, which is just simply a basic permission, a basic right that can exist. If I were to invite my friends round for some drinks, I would be giving them license to enter onto my property. We can also think of the idea of licenses which are coupled with an interest. The idea being that in order for an interest to be valid, there may be the requirement of license over a certain property. This may exist in relation to various different types of covenant and specifically also things relating to easements, which we'll get to in future lessons' time. This lesson is going to examine the next kind of license which we can think about, sometimes known as contractual licenses, or alternatively you could label it a license coupled with a contractual obligation. Either of those is fine in terms of how you were to define it. An examiner or an individual who is reading a paper or exam of yours would presumably know that you're talking about the same thing if referencing either of them here. So let's just think about it then. So a contractual license, or contractual licenses, or licenses coupled with a contract, may arise in circumstances where you enter into a contract with valid consideration. For those of you who haven't studied contract law so far, you must know that in the English legal system, there is not the recognition of contractual arrangements that do not have valid consideration, or sort of one-sided contractual arrangements. So a contractual license, therefore, will arise out of circumstances where one enters into a contract. This contract has attached to it valid consideration, and this gives you some access to property as part of the license. For example, if I were to purchase a ticket for a theme park, the contract that has been created is the ticket for the theme park, but I also have a license, therefore, to enter into the theme park for the period of time that is allowed under the contract. If I were to purchase a train ticket or a tram ticket, I have license to enter onto a tram or a train for the duration of time that the ticket permits. And so this is the idea of a license which arises out of a contractual arrangement. And simply put, it will begin at the time at which the contract says that the license is valid. So if we go back to that theme park example, if I were to buy tickets for a theme park and it says that I can only use the theme park on the 20th of June, for example, maybe I buy them in advance, then the license does not exist until that contractual time period has begun. And then for the time on the 20th of June, I have license to do and go around the theme park and act, obviously, within the remit of a contract, of course, not causing anything that would get me kicked out of a theme park. This therefore means that if I have a contractual arrangement that exists, and as part of that contractual arrangement, there is the requirement that I have license to enter onto some property. If that license is revoked, then this will amount to a breach of contract, since it is a fundamental characteristic of the contract itself that I have license over that property in question. So again, going back to the theme park example, if I, for any reason, that does not, if I have not breached the contract myself, if I purchase a ticket for a theme park and then all of a sudden some security guards come and kick me out and remove my license, then they have breached the contract, because as part of the contract that I have with the theme park, I have license to enter onto their property, onto the theme park. That's the whole point of the contract in the first place. Now, if I were to breach the contract, if I were to do something and act in a way that would get me kicked out, then I would be the one in breach of the contract, and therefore my license would be revoked. It does not mean, however, that there is no way to revoke a contractual license. It can be done in some circumstances where there is reasonable notice, and that there is the acquisition of damages as a remedy for the breach of that contract. So there are theoretical examples for where we can understand a license actually be revoked in a way that does not just automatically arise out of a breach of contract. If reasonable notice is given and there is damages or remedy for contractual breaches, then this can be a valid way to revoke a contractual license. There are, of course, however, limits on the termination of a contractual license. The courts have recognized that in certain circumstances, a license was intended to be irrevocable, that you cannot revoke a license in a contractual arrangement. For example, in cases where a contract is formed for the purpose of doing work, and that the license is not to be revoked until that work is performed, until that work has been completed. In those kinds of circumstances, therefore, an injunction, in fact, may be granted, and that this injunction could be granted to prevent the premature termination of a license. And such examples can be given to illustrate this point. And I point here to the case of Winter Garden Theatre versus Millennium from 1948. In this case, the defendants were the owners of a theatre who had granted license to a theatre company. Within that license, there was the option for the contract, and as a result of which the license itself, to be extended. There was an extension option. When the claimants, the company, sought to extend, the defendants instead sought to terminate the license. This was in fact a part of the breach of contract, since there was no provision within the agreement to allow the defendants to terminate the lease. And so there was a disparity here between the Court of Appeal and the House of Lords, because the Court of Appeal, in fact, suggested that the license had not been revoked, whereas the House of Lords, in fact, said that it had been revoked. The disparity in judgment in this case came from the fact that there was a different interpretation of the way in which the contract was to be viewed. On the one hand, we have the general view here being that the terms of the contract are particularly illustrative as to whether or not a license which arises out of said contract can be revocable. Now, obviously, because the House of Lords disagreed with the Court of Appeal and the House of Lords had the final say, it was the decision and the ruling of the House of Lords which actually had weight in this particular judgment. But what this does is illustrate quite an interesting disparity, like I say here, a disparity between the reasoning and the rationale behind the Court of Appeal on the one hand, and the House of Lords on the other, which have then viewed this entire situation slightly differently, in a way that therefore meant that there had been a revocation of the license, whereas the Court of Appeal believed that there had not been a revocation of the license.